A number of questions have come up regarding cash just recently, so I thought I would cover off a few of those in this video. But as always, none of this should be taken as legal advice and certainly not as tax advice. For that, you need to go to your accountant or directly to HMRC. But either way, welcome back to my channel. But if you're new to me, I'm a barrister who helps you understand law. And in this video, we're talking cash. So where to begin? One question that has been asked a number of times is whether or not a shop can refuse to accept cash from you. Many people, and dare I say it, many videos on TikTok arguing that shops cannot refuse cash because it's legal tender and therefore they must accept it. You can tell by the tone that I'm telling you this that that is plain wrong. The shop can refuse to accept cash if they wish. Conversely, the shop can refuse to accept card payments as well. They can refuse credit cards, they can refuse debit cards and credit cards and insist that you use cash only. That's because it's a private business and they can choose how they accept payment. That goes for shops, that goes for taxis, and so on and so forth. These are just some of the ways the question's been posed because some people didn't have cash and the shop or the taxi insisted on cash. Now, they can insist on cash, but there is a caveat with all this because if they didn't make it clear at the outset that they only take cash or they only take card, and then when it comes to pay you don't have one or the other, then it isn't automatically dishonest that you're leaving without paying because you're not paying with the form of payment that they only accept. Of course, it won't be automatically dishonest because if you are intending to pay, just not in the way that they accept payment, unless, of course, you've researched it beforehand and you're only going with that form of payment because you know that they haven't made it expressly clear otherwise, then that might lead to it being dishonest. But even then, it's a little bit of a stretch because dishonesty is quite a high bar. A court, which includes the judge and the jury, is not going to be quick to impart a dishonesty element upon you if you've got a reasonable excuse or a reasonable explanation for what you're doing. Other forms of question are derived from the use of Scottish pound notes. Now, shops, again, can refuse to take those, or they can accept those. That is, again, down to the shop. There are technical exceptions regarding the use of legal tender, which I've explained in other videos, but even then, in modern days, the court will only take a cheque. At least that's what the current guidance on the websites say. Other questions come up such as, is there a limit that I'm allowed to pay in cash? Usually because someone's making a large purchase and they want to pay it all in cash for whatever reason that they might want to do that. Now, again, there is no strict legal limit on how much you can pay in cash, but in reality, the traders, the dealers, or high-value dealers, as they're known to the revenue, will have to register as a high-value dealer and possibly report such high-value transactions, particularly if they are being paid in cash. And you'll probably find in reality that many of those dealers simply won't take a certain amount of money in cash over and above a certain amount. Other questions include, can you, should you, and can you be made to pay your employees in cash only? Again, yes, you can, but there are rules involved, which obviously include tax and national insurance. And if you are, for example, paying your employee free of tax, then this should be reported when you're doing your own company tax returns as to how much net that you've paid your employee and whether or not you've paid tax on their behalf. Again, something to be talking to your accountant about or directly to HMRC rather than guessing and getting it wrong. Other questions involve coming into and going out of the UK carrying cash. Now, there is a limit, that's £10,000, which you must declare. If you don't declare it and you can't explain where it's come from and all of those sorts of things, you risk having it seized. Another very practical thing to be aware of is that if you have a large number of cash transactions coming into or going out of your account, then the bank is likely to get suspicious. And if the bank can't explain these cash transactions, either the origin or the gross amount of how much has gone in and out of that account, they might be looking to close your account and possibly even consider reporting your account as a potential or suspected fraud. What's worse in these situations is that the bank is probably not going to tell you any information at all about this. They will probably simply close your account and give you a very limited amount of time within which to tell them where to send the balance within that account. In quite a few cases that have been reported to us, the customer has reported the business as being fraudulent or the transaction as being fraudulent, And the bank, being fairly jumpy these days, just block the account and then make the company go through several hoops to prove that the transaction was legitimate, there was a real invoice, it's a real business, it's actually trading, and all of these sorts of things. This is a huge inconvenience to businesses, although it usually will get resolved so long as it's a genuine transaction, there's a genuine invoice and all of these sorts of things. But all the more reason why, since we're talking about cash, if you are accepting cash for something or you're paying out cash for something, always keep the documentation, even though it might be paid in cash. To talk about the elephant in the room, obviously lots of people want to make payments in cash or receive payments in cash because they want to avoid tax. Now, make no mistake, that's a criminal offence. If you're evading tax and you're caught, then at the very least, you're going to be made to pay that amount, usually with a fairly hefty penalty. At worst, you'll be looking at prison time. So even if you're involved in transactions that are perfectly legitimate, I would always say make sure you get them all documented, and if you do receive cash, get the person paying you to sign to say that they've paid in cash and that you've received that cash. You countersign it, ideally in a wet ink signature. This is one of the few times you'll hear me recommend a wet ink signature, because there's lots of talk of wet ink signatures, particularly with warrants which don't require a wet ink signature. This is simply signing with a pen, i.e. a real signature, not just an electronic one at the bottom of an email. Interesting case in point, when you're paying funds into a court, you must sign that form in a wet ink signature. Either way, it's always better that you've got either a receipt book or some kind of logbook where the person is signing to say that they've received the cash, so if there's ever any problem moving forward, you've got a record that they received that cash. It's their signature, and the court is likely to trust that signature. So if it ever comes up in discussion, the court is likely to believe it. Conversely, whilst we're on the tangent of signatures, we've had some cases where apparently there's been a guarantee signed against a credit account for a certain business, but the customer claimed that the signature was taken from a public document, which was a public brochure for the company. They alleged that the company in question took that signature from a public document, removed the background, dropped it onto another document and passed it off as a genuine guarantee signed against the credit account. Now, in that case, because the court did not have a copy and was not presented with a copy in evidence of the original signed agreement, and the court took the view that the signatures were so similar that it was quite likely that it was taken from this public document, publicly available document, as against the company trying to prove that it was originally signed. The court took the view that if it was so important for the company to rely on to guarantee this many tens of thousands of pounds by way of guarantee, they should have kept the original, because of course a guarantee signed by hand is going to be much more persuasive. So I hope that addresses some of the questions. Doubtless there will be many more. Drop those in the comments box below. Let me know what you think about any of these. I personally think eventually cash is going to disappear. Let me know whether you agree with me. Remember to like this video, and as always, thank you for watching.